Thanks, everybody. You can have a seat. Good morning. I appreciate the members of the media coming this morning. There was a Syracuse.com article recently about my thoughts on the new bail legislation. I didn't realize that our intrepid reporter, Dougherty, was here and wrote that article because I intended to speak about the new bail legislation today. I've been involved in criminal justice for over 30 years. 18 of those years as a judge. I've handled thousands upon thousands of cases. I am not an alarmist. I like to think I'm a realist. I've never in 18 years had a reason to address the media like I am this morning. Before I go on, I would like to say that I think no one, at least as much as me, understands that the rights of the accused are tantamount. They are set forth in the Constitution, and including the right for bail. I make sure as a judge to ensure that those rights are taken care of, are ensured, are protected every single case that comes before me. It's January 3rd. The new bail legislation went into effect 2 days ago. I refuse to call it bail reform. The legislature and the governor have, in my opinion, by this legislation, usurped the discretion of the judiciary, a co-equal branch of government. I realize that the legislature and the governor have the function of creating, passing, and signing into law legislation, including legislation that affects the criminal justice system. But this new bail legislation is so short-sighted, so ill-conceived, and potentially it's dangerous to the community. If the legislation had passed laws that said there should be a presumption of no bail for violations and misdemeanors with some enumeration of discretionary factors for courts to consider, there'd be no problem with that. That'd be fine. But to unilaterally dictate that we cannot set bail for the great majority of felonies not only strips the judiciary of our discretion, it is so misguided as I said, to be dangerous. We judges are being told by the legislature and the governor that there are a multitude of serious criminal charges where we cannot consider setting bail. It'd be interesting to know how many of those legislators that voted for this so-called reforms ever set foot in a criminal courtroom. Because this is what we judges do every single day. We consider bail on an individual, case-by-case basis, the way the public would want it done, not lumped together as a group with no individual consideration. The system in place last week, last month, last year was fair to everyone. Did it need to be tweaked? Did it need to be changed? It did. But this isn't a tweak. This new legislation is like killing a mosquito with an atom bomb. Until 2 days ago, the arraigning judge, with the facts of the case before him or her, with the defendant's criminal record before him or her, would arraign the defendant with an attorney present for the defendant. And the judge would determine the appropriate bail based on all the available information, again, in a case-by-case individual consideration. If the defendant wasn't satisfied with the bail that was set, that defendant could petition to a so-called higher court for a bail review. And if again not satisfied, the defendant could then make a further petition. Now, without any discretion, without the value of the various judges' years and years of experience, our hands are tied. And we have no power, no discretion, and no ability to even consider setting bail. Let me give you all an example of how misguided this is. If a defendant fails to appear in court under this new legislation, after we've told the defendant in court with his attorney present, his next court date, we give him a sheet of paper reminding him of his next court date. If he doesn't come to court, we can't issue a warrant without sending him a further letter, a phone call, or a text. And if he fails to appear again in court, unless it can be shown that his lack of appearance was willful and persistent, we still cannot set bail. The New York State courts, the New York State judges, are not allowed to consider certain factors in a defendant returning to court. And I'll give you some examples of that, but here's an example. If someone breaks into your home, they're accused of breaking into your home, and they steal property, or if 5 20-year-olds or older are accused of surrounding your 12-year-old daughter and hitting her and stealing her bicycle, we can't set bail. We can't consider setting bail. We have to release the defendant. That's the new law. There's other examples that we're all aware of. Well, one was in this court. I had a defendant who was charged with criminal possession of controlled substance in the 3rd degree. He was indicted for that. That's a B-level drug felony. He had just recently got out of state prison for killing someone. Manslaughter in the 1st degree. He served over 10 years. Under the new legislation, I wouldn't be able to set bail. I wouldn't be able to consider setting bail. I would have to release him back to the community. And another example that we're all aware of is the bank robber that was convicted 3 times in this community of robbing banks, recently got charged in Albany with robbing a bank, had to be released. The judge could not set bail. Many advocates of the new bail statutes compare ours to the recently enacted New Jersey bail legislation, which has been in effect for over a year, and note that there's really been no problems in New Jersey. What they fail to point out are the differences between their legislation and our legislation. It's a difference between sensible legislative reform and mindless, lemming-like political action. In New Jersey, the courts, in determining bail, can consider the following factors before releasing a defendant: danger to the community, risk of reoffending, prior history of failing to appear in court. We can't consider any of those factors. It's senseless. It's absolutely senseless. The law, the new bail legislation, is now the law. I'm sworn to follow the law, and I will. But I couldn't go forward this year without putting on the record my thoughts, my feelings, and my objections about this new bail legislation. I appreciate you all coming and listening to me make my little speech. Thank you.